All right. Well, thank you so much, everybody, for joining. Wanted to give folks some time to join. I know everybody's running from meeting to meeting, but welcome to the California Labor Commissioner's update on COVID-19. It's hosted by Augusto, and we're so happy to have this opportunity to share this information with our customers. And just wanted to give a couple of housekeeping reminders before we go ahead and get started. First of all, of course, thank you so much for joining us today. We're streaming live, so please hang in there in case something happens. Technical things do happen. We're all doing this from home. So just hang tight if something happens and we'll reconnect. If you have any questions throughout today's event, please leave them in the Q&A and we'll take questions at the end of the presentation. During the Q&A, not every question will be answered, but we will give it our best effort. And afterwards, this deck will be shared with helpful links and we'll email them out tomorrow. So you can look out for other resources in the chat. But good morning. We are all excited to have you joining us today. My name is Shelly Abril, and I'm from the payroll compliance team here at Gusto. We are the people platform that enables over 100,000 small businesses nationwide to pay, insure, and offer benefits to their teams. We know that during this pandemic, small businesses have had to face a number of tough challenges, including a changing landscape of legal obligations. So we are so grateful to be able to host the California Labor Commission's office today for this webinar and to touch on an important and timely issue around sick leave and other wage hour concerns that small businesses should have in mind. Also with me today from Gusto is Michael Cole. He is our in-house employment counsel. He has over 15 years of experience counseling and advising large and small employers in multiple industries on the full spectrum of employment law matters, and with particular emphasis on California employment law. And from the Labor Commission, we also have Vaughn Boyinger. Vaughn is the Senior Deputy Labor Commissioner with the California Labor Commission. And he has over 30 years of experience in the area of administrative hearings and claims management. And also joining us today is Max Norris, who has been a staff attorney for the California Labor Commission since 2012, shortly after he graduated from UC Hastings College of Law. So thank you so much for joining us today. I wanted to share too that this was brought to us. This program is sponsored by Lilia Garcia Brower, who's California State Labor Commissioner, through the Labor Commissioner's Business Engagement Program. It's a series of webinars designed to help businesses understand the wage and hour laws in California and how to avoid common violations. Garcia Brower was appointed by Governor Newsom as the State Labor Commissioner on July 29th of 2019. And as Labor Commissioner, she oversees the primary law enforcement agency for workplace protections. The Labor Commission has 19 offices throughout California and employs 700 hardworking public servants who investigate and adjudicate a wide range of workplace violations, from unpaid wages to retaliation. So want to kick this over to our experts. And so I'm going to pass this over to Vaughn, who's going to get us started.
All right, good morning and thank you.
Vaughn.
Yes, good morning and thank you. And on behalf of our Labor Commissioner, Lilia Garcia Brower, we do thank you for attending this morning's presentation. We commend you all for your interest in our California labor laws. Please note that this presentation has been designed to help employers understand our labor laws and thereby help reduce labor code violations. And as in all things, there are disclaimers. So this morning, this is ours. The information is provided for general information only. None of the information provided here should be interpreted as providing legal advice or a separate attorney-client relationship. And applicability of the information discussed may differ in individual situations, which is to say that something that might sound exactly the same, but might have an if, and, may, or can completely change the context. Therefore, you should not act on any of the information presented here without first consulting an attorney about your particular situation. And on our next slide, there is the Commissioner's Office overview. The mission of the California Labor Commissioner's Office is to ensure a just day's pay in every workplace in the state and to promote economic justice through robust enforcement of our labor laws by combating wage theft, which could be something as simple as not paying employees or not paying employees minimum wage, protecting workers from retaliation and educating the public. We put earned wages into workers' pockets and help level the playing field for law-abiding employers, which is to say that if you are doing everything all by the rules, you've got workers' comp, you're paying everybody as you should and the wages that you should, and somebody who isn't following our laws is continually underbidding you, we want to know about it. And therefore, you can contact us through our email address at makeitfair@dir.ca.gov. And on our next slide, you'll see here is a representation of our website. It's actually pretty user-friendly. If you look at the query box up there on the black stripe at the top right, you could put in something as simple as overtime or alternative work week, anything like that, and the information you need is right there for you. If you look on the other side of that same black stripe where it says labor law, if you were to click on that, if you were on the actual website, what you would see is locations of our offices and contact information for our offices that are in the cities and counties where you conduct your business. So there are ways to get in touch with us, but generally you can find everything you need right there from our query box on our website. And in California, all workers have rights. Workers in California have the right to file a wage claim or report labor law violations when their employers don't pay them the wages or benefits they are owed. Workers have the right to file a retaliation claim if the employer retaliates against them for exercising a right provided by that law. California labor laws protect all workers regardless of immigration status, and it is illegal to report or threaten and call immigration authorities on a worker for exercising their rights, to file false police report against a worker for exercising their rights, or to threaten relatives of a worker who exercise their rights. Bottom line is, if you're working here in California, you have rights. And now we move into paid sick leave. AB 1522, goes as follows. You can accumulate paid sick leave hours from the first day of work. Can't take it until you reach the 90th day. Whether you're full-time or part-time, you will accrue 1 hour of sick leave for every 30 hours worked. Employer can cap paid sick leave use at 24 hours or 3 days, whichever is more. And the reason why there's a difference is because some employers do have approved alternative work weeks where employers might work 410s or 312s. And so therefore, it would be more applicable to use those rather than the 24 hours or 8-hour shifts that you normally would think of. And continuing on, employer must permit employee to use accrued sick leave on the 90th day of employment or upfront hours, which means you can front load those on the 120th day of employment. The employer needs to provide notice of how they will provide paid sick leave upon hire. In other words, there has to be a notification to employees upon hire what the policy is and how they can accrue. Accrued hours must be reflected on wage statements or the pay sheet that accompanies the paycheck. And okay, and on our next slide, who can use what I can use paid sick leave for? Workers can use the hours for absences due to illness, diagnosis, care, or treatment of an existing health condition, includes COVID testing and self-quarantine as a result of potential exposure to COVID-19. Please note that AB 1522, our paid sick leave, is not specific to COVID. It's for all related matters to an employee being out sick. And so preventative care for employees or the employee's family members are also included in this. And next.
Sorry.
Nope, back up one. There, no, one more. There we go.
Did I go too far? There, that's the one.
No. Okay. Okay, so yeah, it'd be the very next one.
That's the next slide.
There we go. There we go. Perfect. So an employee, you must know or need to know that employee can put either an oral or a written request in. It doesn't have to be written. You can't require them to make it written. It can be oral or written, and they can speak to the supervisor. They don't have to speak to the owner, so they can just tell whoever's in charge. An employer cannot deny paid sick leave simply because a worker does not have a doctor's note. In fact, for the first 3 days of the sick leave, you can always offer more than 3 days, by the way. But for the first 3 days, you cannot ask for a doctor's note for the first 3 days. After that, you can. Payment must be on the next regular payday. Employers cannot require an employee to use paid sick leave. It's the worker's choice. Let me say that one again. You can't require an employee to use their paid sick leave. It is the worker's choice. And on our next slide, supplemental, there is a supplemental paid sick leave that's still in effect. It expired December 31st, 2020. However, if you had a claim or a violation of the sick leave law that occurred prior to December 31st, 2020, and your employer has 500 or more employees, your claim will be heard by the Labor Commissioner's Office. And that is to say that if you you may have gotten sick on 12/31, didn't find out that you had COVID, for example, then you would still have the supplemental paid sick leave for the expressed amount of time of up to 90 days. And so therefore, we would retain jurisdiction over that period of time. Workers taking the SPSL as of December 31st may continue to take leave they are currently on, even if their sick leave extends past December 31st. So as mentioned, if you went on 12/31, then you still qualify even at this point in time, you would still be covered. And on our next slide, employers' requirements, they have to pay sick leave on time, by the payday after the leave was taken, or when they can reasonably tell you that they need to be on sick leave. You know, for example, what if you're in a coma or something of that nature? You couldn't tell them right away, the employer. So the idea is for employers to understand that it has to be a reasonable request by the employee, and that's what the Labor Commissioner's Office means by the reasonable request. Keep records of hours worked, paid sick days accrued, paid sick leave used by an employee, and provide such information upon request by the employee. Provide workers with notice of an amount of sick leave available at the time as the payment of wages. And you may not require employees to find replacement workers or a doctor's note. And you must require posting of a notice of sick leave to your employees. And here you'll see a sample of a paid sick leave notice that you would give employees, advising them of their rights and of your obligations as an employer. And so there's where you can find the link. If you want to take a picture of it real quick, that's fine. And short of that, I'm going to hand off the Labor Commissioner's presentation to our Labor Commissioner Staff Attorney, Max Norris. Max?
Thanks, Vaughn. My name is Max Norris, and I've been a staff attorney for the Labor Commissioner for the last 8 years. As background, employers must pay workers for all hours worked, including the time that a worker is under control of the employer. The term hours worked means the time during which a worker is subject to the control of an employer, and includes all the time the worker is suffered or permitted to work, whether or not required to do so. So along these lines, where an employer requires a worker to complete a medical check, including a simple temperature check, in order to begin a shift, this must be compensated. This is compensable time. Employers must compensate a worker for that time worked, even if the temperature check takes only a small amount of time to complete and record. Employers who require a COVID-19 test or vaccination must pay for the time it takes for testing or vaccination because such time would constitute hours worked. Employers cannot require the worker to utilize paid sick leave or PTO if the time is considered hours worked, as referenced above. If an employer expressly requires a vaccine or test, then the employer must also indemnify the worker for costs of it, if any, and any associated costs of travel, or any associated costs such as travel. And you can see our most recent FAQs. I think Mohini will drop that link in the chat for us. Next slide, please. So the Labor Commissioner enforces retaliation protections in many senses. So we're going to go over those that kind of apply here. Workers have the right to use accrued sick days, ask about or complain about sick day issues, attempt to exercise the right to use accrued sick days, even if they don't have any, file a workplace complaint or cooperate in an investigation as to paid sick leave or generally, and to be free from retaliation in all those circumstances. And the retaliation section of the Labor Code relating to paid sick leave is Labor Code section 246.5. Basically, retaliation in a basic sense is where an employer punishes a protected activity with what we would call an adverse action. So in this case, the protected activity that we're talking about is the use, complaints, discussion, or attempted use of this protected paid sick leave. So thus, where there's a complaint, it would be deemed retaliation if the employer took an adverse action, such as demoting them, cutting their hours, cutting their pay, or terminating them, suspending them, stuff like that. Next slide, please. Great. So Labor Code section 6310 comes from more of the Cal OSHA section of the Labor Code, but is enforced by the Labor Code. So this is where the worker would be protected as far as a request for protective equipment, personal protective equipment, PPE, asking questions about safety protocols, seeking assistance from a local or government agency related to the workplace safety, filing a worker health or safety related complaint with these agencies, or even asking questions or complaining to their supervisor, manager, or owner about workplace health or safety. So this is basically giving protection to workers from illegal retaliation for the protected activity of worrying about their health and safety in the workplace. Next slide, please. Similarly, Labor Code 6311 protects an employee who refuses to perform work that violates an occupational safety or health standard and creates a real and apparent hazard that puts the employee or their coworkers in imminent danger. In most areas of California, at least during periods over the last year, COVID-19 appears to create the real and apparent hazard referred to in this law. So basically where folks refuse to perform work based on, and there is a real and apparent hazard of COVID-19, you would not be allowed to punish them for refusing to work. Pretty straightforward, but something to watch out for. Next slide, please. Keep in mind that there are a whole bunch of other protected leaves outside of what wage and hour law would say, such as for Department of Fair Employment and Housing and all sorts of things like that. An additional leave option for parents that, that we might see coming from our wage and hour section and the California Labor Code is leave for parents. So workers at a work site with 25 or more employees, a parent can use up to 40 hours of leave per year for specific school-related emergencies. And this was passed long before, or a year or so before COVID, I believe, but did include school closures. So, you know, we see this as something that might be implicated as, especially towards the beginning of the pandemic when schools were closing. Employer policies determine if the leave is paid or not. But again, the employee cannot be mandated to use paid sick leave or their own PTO. They can take it unpaid if that's their wish. Parent may use any available paid sick leave to be with their child as preventative care under the paid sick leave laws that we discussed, and employers cannot retaliate against you for using this type of leave. Next slide, please. So a very old and very important labor code section is Labor Code Section 2802. This requires that employers indemnify for expenses reasonably incurred. Now, most people will talk about this as a reimbursement type statute, but it goes a little further because the legal term indemnity is quite a bit broader than a reimbursement. But for our purposes and most purposes in basic employment relationships, this includes stuff like costs of travel incurred, tolls, parking, mileage, meals, a reasonable portion of vehicle insurance, uniforms and equipment that are required by the employer. And also, as far as COVID-19 goes, the employers are required to pay workers reasonable expenses where the employer requires that a worker complete a medical check using a particular cell phone application. Kind of as background, back in 2014, an appellate court ruled that personal cell phone use is covered. So is it something that an employer has to indemnify and should provide a reasonable reimbursement based upon the amount of use and the type of plan and who's paying for it, stuff like that. But basically what that kind of telegraphs to us is that as people move towards work from home, there may be more litigation around what expenses employers should indemnify for. So best thing to do is to provide the tools necessary for your employee to complete the job, or provide a reasonable reimbursement where the use of some device or anything like that would be required by the employer. Next slide, please. Great. So one thing to keep in mind is that although a lot of folks are working from home, the requirements for meal and rest periods are still in effect. So all employers are required to provide a duty-free meal period. This comes from our IWC wage orders and the labor code. And in most cases, an employer is required to provide an employee with a 30-minute duty-free meal period where a worker works a shift of at least 5 hours. Where an employee works 10 hours, there would be a subsequent second meal period. A meal period is a non-compensated duty-free period unless an employee works through it. If an employee works through it, there are some exceptions, but for the most part, they would need to be compensated for the time worked and paid a premium hour as a wage premium. Duty-free meal periods are an affirmative duty for an employer to provide. A very recent case that known as Donahue versus AMN stated that where an employer fails to record the taking of a meal period, there is a presumption that it was not taken. So this really cues in as a factor in your record keeping, especially for hourly employees. Also make sure that employees are taking 30-minute lunches or more, as Donahue versus AMN took issue with that employer's rounding policy. So if anything, if an employee takes like a 26-minute meal period, that's just not going to count, unfortunately, per Donahue. Next slide, please. Similarly, rest periods must be authorized or permitted. Rest periods stem again from our IWC wage orders and the labor code and require an employee who works a shift of at least 4 hours, not 5 this time, get a 10-minute duty-free rest period. A subsequent rest period up to as many as 3 or 4, where work hours are quite long, would be due for each major fraction of 4 hours worked. So if you get out to about 6 hours, it's going to require a second 10-minute duty-free rest period. The duty-free rest periods should be made available as much as practicable in the middle of the 4-hour period, as opposed to the end or beginning. Rest periods are compensable. Thus, employees do not clock out and they are compensated for the time. Employers must authorize and permit all employees to take rest periods. So just notice the difference in the language that comes straight from the statute. There's an affirmative duty to provide a duty-free meal period, as opposed to an employer having an affirmative duty to authorize and permit a duty-free rest period. There are some more stricter parts of rest period, and one is that there's no such thing as an on-call rest period, and there should not be restrictions as to geography besides what's literally physically possible within the 10-minute period. And that stems from a case, Augustus versus ABM Security, discussing on-call breaks for security workers, which were ruled not to be a compliant break with rest periods due. So where a rest period isn't authorized or permitted, there would be a premium hour of pay due to the employee as a rest period premium wage. And like the meal periods, the premium wage as a result of violation is capped at 1 hour per day. So if there are multiple lunches or multiple break violations, it would still just be the 1 hour premium pay. Next slide, please. Employer record keeping requirements. So similarly, just because an employee is working from home does not change an employer's obligations to keep legally required records. So some of those legally required records are time, pay, and wage statements pursuant to Labor Code Section 226 and IWC orders at Section 7. What basically these are the itemized wage statements that everybody gets with their paychecks that are a requirement of the law, as well as the time and pay records that are behind the itemized wage statements that actually show all the moving pieces that get those calculations onto the pay stub. An employee during the pandemic would still have a right to review or copy pay stubs and records per 226 or personnel files per 1198.5. So you still want to provide a reasonable opportunity for the person to view their file, whether employed or recently separated from the company. That being said, you can, reasonable would be different in a pandemic than it would be outside of a pandemic. So probably the best thing to do would be to provide an electronic copy and avoid somebody needing to come into the office, but as that is an option for compliance. Notice of employment conditions at time of hire. This is one I really like to stress. So at the time of hire, Labor Code Section 2810.5 actually requires that the employer put down a whole bunch of the basic terms of employment on a writing and then have themselves and the worker sign the writing. This basic little contract should set the terms of the relationship, how much the person is going to be paid per hour, what the title of their job is, what their schedule is, stuff like that. And 2810.5 has some enumerated things, so you can check it out in the labor code itself. But this is something that is rarely actually complied with, and because there's not a penalty that stems from it. So people, for some reason, don't necessarily pay attention. But in reality, there is a penalty that stems from it, because the penalty in reality is the argument over what that rate of pay is. If you put it down in writing, everybody signs it, and you keep it in an employee's file, there isn't going to be confusion about these things. If you don't have a 2810.5 compliant sheet in the file and didn't go through the proper steps to establish that, it's going to leave that as a question mark for everybody and possibly lead to litigation or at least claims being filed before things could be cleared up, which can cost time and money just to get something cleared up. And also, generally, the effect on enforcement and litigation Hernandez v. Mendoza is the seminal case from 1988, but there was a more recent case, Furry versus East Bay, that did a nice job of laying out the burden shifting. But basically, the Supreme Court of California and the United States have ruled that where an employer fails to keep legally required records, it cannot be used to prevent the employee from recovering damages. Thus, an employee is allowed a burden shifting to bring forward a reasonable recollection based nothing more on their word, basically, of what happened and why they weren't paid all their wages. And an employer who, again, has failed to keep accurate records, especially those time records and pay records pursuant to 226, but also things like 2810.5, the employer cannot rebut with their own approximation, but needs to rebut with specific evidence. And so this sets up a large advantage in the way evidence is seen by a judge or jury in these wage and hour matters where there's a finding of failure to keep accurate or any records for that matter. Next slide, please. So split shifts stem from our IWC wage orders. And basically it is a requirement where a employer sets a work schedule which is interrupted by a non-paid, non-working period established by the employer other than a bona fide rest or meal period. And this has been ruled as longer than an hour. So we see this a lot of times with restaurants where restaurant workers will work a lunch and then have a 2 or 3 hour, break in their employment, and then need to come back for the dinner shift or, stay there oftentimes at the workplace. Basically, what the wage order requires is that when an employee works such a split shift, that the employer take into account an additional hour it added only to the minimum wage requirement. So that's the key here, is that it extends the minimum wage requirement. So if you're paying just the minimum wage or slightly above it, you will need to worry about split shifts, because adding an additional $10, $13 an hour to the person's shift may not be covered by, won't be covered by minimum wage, and it may not be covered even by $1 or $2 or more. Folks that make significantly more per hour, this won't be implicated, because the minimum wage at $13 an hour could be easily split over the other 8 hours if there's a higher pay rate, say like $5, $6 above minimum wage. So basically, this is just something to keep an eye out, as this does not change just because we are working from home or have the pandemic going on. And I think that's all we have for today from the Labor Commissioner. If we can get next slide, we have some resources here. We have a hotline, 833-LCO-INFO. And this is kind of a general question line. We also have a confidential paid sick leave violation hotline. So as Vaughn alluded to, an employer who is doing their darndest and going out of their way to do all these things to comply with all the stuff we talked about, you're going to incur costs, whether, whatever that looks like, to do business properly in California. But folks, your competitors who are cutting corners will not incur those costs and likely be able to outbid you or outperform you based on their non-compliance. So we ask both employees and employers to report labor law violations generally, and in this case, paid sick leave violations. And you can visit our website at dir.ca.gov/DLSE. And as far as COVID-19 questions, we have a email address, lco-covid-19@dir.ca.gov. And now I'm going to pass it over to Michael, who's going to go over some differences between the state laws that we just discussed and federal and local laws that may also be applicable to you in California. Michael?
Thank you, Max. Thanks, Max. So I know we spend a lot of time on California requirements, but would be remiss not to also talk about both federal requirements and also local leave laws, as well at the city and county level. So at the federal level, last year, there was the Families First Coronavirus Response Act that was passed as part of the broader COVID relief bill, the CARES Act. It required certain sized employers who had under 500 employees to provide two forms of additional leave: emergency paid sick leave and emergency family and medical leave for certain qualifying reasons. The paid leave was funded through federal payroll tax credits. The mandatory nature and the requirement to provide the leave on a mandatory basis, that expired at the end of 2020, but a couple of things have changed at the end of the year and since then. In late December, as part of additional COVID relief that was passed, employers were allowed to extend the credits for unused amounts of the emergency paid sick leave and emergency family and medical leave through March 31st for those who do decide and did decide to voluntarily continue to provide these forms of leave. And then the recently enacted American Rescue Plan has further extended these credits through September 30th of 2021. Not only that, but the American Rescue Plan has also reset the emergency paid sick leave limits effective 4/1/21, and also has increased the aggregate tax credit that are available for employers for the emergency FMLA portion to up to $12,000. We'll talk a little bit in the next slide about some of the more specifics for those that are going to be voluntarily providing these forms of leave. So originally, the FFCRA provided that employees of covered employers were eligible for 2 weeks, up to 80 hours of paid sick leave. And that could be for reasons like they're unable to work because the employee is quarantined, they're experiencing COVID-19 symptoms, and they're seeking a medical diagnosis. If it was for one of those covered reasons, the credit was at 100%. You can use up to the 80 hours at 2/3 the employee's regular rate of pay because the employee is caring for someone in quarantine to care for a child whose school or child care provider is closed due to COVID-19. In addition to that, there was a total of 12 weeks of expanded family medical leave, the first 2 of which were unpaid. The remaining 10 weeks paid at 2/3 the employee's pay, specifically where the employee is unable to continue to work due to the closure of their child's daycare or school closures due to COVID-19. Again, these leave requirements are no longer mandatory, but employers under the American Rescue Plan and other extensions can continue to voluntarily provide them and take advantage of the tax credits. On top of that, the American Rescue Plan also expanded the above eligibility reasons to now include other things like if an employee is out because they're seeking or awaiting a test or diagnosis for COVID-19, employees can also take leave. You can offer leave and you can get the credit if they're out because they're obtaining the vaccine. Likewise, for employees that are experiencing injuries or conditions and they're recovering from immunization, that's also now a covered reason under the American Rescue Plan. And in addition, whereas before, under the family medical leave portion, you can only take leave and qualify for the credit due to school closure. That's now been expanded to include all of the same reasons as emergency sick leave. And in addition to that, the first 2 weeks are no longer unpaid and the whole 12 weeks are paid. Just one thing to keep in mind here, again, even though it's voluntary, if you are going to offer it and do seek the tax credit, then you are taking on the obligation to comply with all of the leave requirements under the FFCRA. So if we go on to the next slide, moving on to local requirements. We're not going to be able to get into all of the details here, and this is just sort of to highlight sort of the myriad of different requirements. In addition to California state law requirements, you need to remember that there may be additional obligations under local, municipal, city, and county laws. These are just some examples. You should definitely check with your local county and city just for the most up-to-date requirements. Some of these local cities and counties have their own paid sick leave requirements. In addition, some municipalities also passed last year obligations to provide emergency paid sick leave for COVID-related reasons. These are examples of cases in which they've all been extended and in some cases expanded in 2021. Again, we won't have time to go into all the details, so I encourage you to, again, check your local city and county laws just to make sure you're aware of the most up-to-date requirements here. But on the next slide, I can highlight some of the key differences with California law at the local level when it comes to sick leave law. Again, remember, where local paid sick leave laws differ from state requirements, you need to follow stricter requirements. State law, federal law, et cetera, it all provides a floor. It's not the maximum. This is just a non-exhaustive list of some callouts where there may be differences or stricter requirements that you should be aware of. For example, annual use caps. Some local laws do not permit annual use caps in terms of how much leave you can cap an employee to use in a particular year. San Francisco is a good example of that. In some instances, local laws provide higher accrual caps. There may be differences in who's covered in terms of how you define a family member and how coverage is determined for an employer and whether you need to comply. Permitted uses may also be broader under local laws beyond state law. Just for example, Emeryville allows use of time for taking your service dog to the vet. San Francisco allows use for bone marrow or organ donation. Covered family members, again, there may be differences in terms of how that's defined and who you can take leave for. So for example, under some local laws, you're allowed to actually designate an individual to take paid sick leave for, even if you're not related to that person through blood, marriage, or otherwise. Increment use, so there may be a lower increment use in terms of requiring employees to take leave in certain increments. So again, for example, San Francisco, you can't require employees to take leave in increments in more than 1 hour. There's different impacts in terms of if you're going to rehire employees within certain times, if you need to restore their balances, record retention periods may be longer, and there's going to be additional posting requirements for employees you have in those locations. Again, definitely consult your local county laws to make sure you're complying with the most up-to-date laws, and always encourage and recommend to consult your HR advisor and employment counsel for further advice in this area, given the differing requirements, federal, state, and local. And with that, I'm going to turn it back over to Shelley.
Thank you, everybody, and thank you to the presenters today. I did want to share a couple of resources. I know Max shared this earlier in his presentation, but we'll have these at the end of the presentation just so you can find them quickly. More resources from the Labor Commission, including the hotline for reporting paid sick violations, and then links to the website and email for COVID questions, as well as the phone number to call in case you have additional questions. And then we've also got this set up for if you want to get notifications direct to your inbox from Gusto regarding COVID legislative changes and other information related to COVID-19. You can sign up on Gusto's website by going to this website address. It's gsto.co/CANL. And you can sign up to receive those updates direct to your inbox, just so you don't have to keep coming out and peeking at our website to see what's changed. I did want to get into Q&A. We have actually quite a few questions have come in, which is pretty exciting. And so I'm going to go through a couple of the ones that have come in hot off the press here. So give me just a second to pick one here. One question that we have is, can we use paid sick time for COVID vaccinations or prearranged doctor's appointments? And then a second part to the same question is, how about dentist appointments? And I think some of these questions we may have already answered in the presentation, but folks may have joined a little later, so I figure it would be good for us to cover quickly if we can. So I don't know, Max or Vaughn, do you want to take that one?
The answer is yes, you can.
Yeah, so why the answer is yes is that paid sick leave allows for you to take it as sick time, you to take it as sick time for a family member, or for preventative care for yourself or a family member, right? So obviously a vaccine would be preventative care, and so would a dentist or prearranged doctor's appointment. So it's not just cough, cough, I'm sick today. It can be, you know, I have a therapist appointment, I have a doctor's appointment, I have a dentist appointment, And really, again, the employer should not be digging deep or asking for a doctor's note about any of this.
Great, thank you so much. And then one of the questions was, and maybe it's already on that slide, but it says, can you share the California website link regarding the most recent sick leave laws?
So I just
don't know if the link that you provided, okay.
This here is not a labor commissioner link. It's actually the legislature, but I use it quite often because it is updated at least through 1/1/20, which I think is sufficient for this set of labor codes. But this landing page will take you to Labor Code section 245 through 249, which encompasses the Healthy Workplaces Act of 2014 as it stands, at least as of 1/1/20.
And Shelley, something else that we should probably mention is if you're only working a 4 or 5 hour shift in general, you can't take an 8-hour sick leave day. So only the hours you're scheduled the day that you're calling out sick for are the hours you can put in for.
Okay. One of the questions, understanding that the doctor's note cannot be requested to pay out sick leave, but wondering about requesting for an excused absence, or is that not compliant either?
Well, it would depend on what the purpose of the excused absence was and whether the person was trying to invoke paid sick leave, whether they had it available or not. It'd be something that's probably generally something you'd want to stay away from, steer clear from, because it might be seen as implicating the paid sick leave or an attempt to use paid sick leave. But where this is maybe like a longer leave and not implicating paid sick leave, there are still other programs where you're allowed to ask for a doctor's note, like temporary disability or CFRA type leaves.
Okay, thank you so much. One of the questions was, we have all part-time employees who work irregular hours. How do we determine how much sick time should be given for a sick day? And so, Vaughn, I think you just sort of touched on that.
Right, so for every 30 hours you work, whether you're full-time or part-time, you would absolutely earn 1 hour of paid sick leave.
And as to how much you would give a worker, it would be based on what they were scheduled for the day that they took. So if you're not scheduled at all, then you can't take a sick paid day. If you're scheduled for 3 or 4 hours, then you would get the 3 or 4 hours that were scheduled that's missed.
And the other thing to mention is employers can always offer more paid sick leave. They just can't offer less than the 24 hours or 3 days.
Okay, great. I think we do have a question related to that in just a minute, but let me see. One question is, if we are a mobile business, can this written notice be given to employees instead of posting it someplace when there's no physical office to post it in?
Max?
And right now, everybody's mobile, I guess, right? For a lot of people.
I'm not sure what the answer is exactly on this. I think that you would be much better off doing something along the lines of giving them the notice at the time of hire, or putting it on a virtual space if you have any. But I wouldn't say that this is a settled question that the courts have answered. And most of the noticed statutes that I've seen envision a physical posting, but I'm sure courts would find a way around that, considering the pandemic. So I think it's best practice would be, to try to put it in anything that would be like a bulletin board. If you have spaces like that, whether it's a Slack or other sort of collaborative workspace, or you have like an intranet like we have at the state, where all our documents can be accessed, as a backdoor link, or something like that. But if you're really not that advanced, I would just provide it in writing, either physically or by email.
And probably just to add to that, a couple of other things. Just know that I believe Max has already mentioned it, but we did not relax our labor laws as a result of COVID. So all laws are still in place. The other thing is, I think from a hearing standpoint, if you can show that you've made a good faith effort to inform your employees, that might be a good best practice. But as Max says, there's a lot of this that is not yet settled.
That's super helpful. Yeah, the laws have to catch up to the reality, right?
That's right.
So one of the other questions is, does the travel costs include mileage reimbursement to a test or vaccination site?
So I'll take that one. Yes, where the test or vaccination is required by an employer. So that's the key there. So where the employer requires the COVID-19 test or the vaccine, then the time spent doing that, including the travel time to and from and the waiting time and all that stuff while you're there for the procedure, is compensable. And during compensable time, if a worker incurs expenses such as driving their car, then a reasonable reimbursement such as the IRS reimbursement amount would be required.
And all that at least a minimum of minimum wage for all hours worked. And it should be notified to the employee in advance if there's some change of wage for this type of travel, et cetera.
Does the sick leave have to be health related? So can employees take sick leave for more general reasons if the employer is fine with it? So this, I think, goes back to, can you pay more? So anyway, curious to hear your answer on this one.
I think where I'm going to go with this is that quite simply, there are very specific reasons under AB 1522 why an employee can take time off. We're not going to probably have any comment beyond that, what an employer chooses to do, but all we can speak to is what the law actually says. So the reasons stated that are allowed are those reasons that are authorized under AB 1522.
When did the update come into effect for the temperature consent that is considered hours worked? Is that update part of, I guess, effective as of January 1st of this year?
No, I think it just stems from the idea that there is no such thing as de minimis time. You can't round, you can't approximate. If the employer has control and the employee is suffered or permitted to be at work or under the control of the employer, then it's compensable time. So there's a lot of case law around these very short periods of time that aren't captured in an employee's pay. A recent example of this is the Troaster v. Starbucks. So the assistant managers in that litigation alleged that they had off the clock time worked when they were locking up the store. So very short period of time, similar to beep, you're good, and you go in. So it actually just kind of stems from the wage orders themselves and the way the courts have interpreted those. And then as us as an enforcement agency have been looking at these things and getting questions from the public, we've made it, public approved guidance more recently, but it just stems from the law as it stands prior to the pandemic.
And also that the employer, because it is their business, either knows or should have known the employees putting in this extra time. That's why they should be compensated.
Great. And then this one actually specifically calls out for Max. So let me see. Do the meal and rest requirements you discussed apply to salaried employees or just hourly employees?
That's a good question. They do apply to all employees, right? The difference is, though, most litigation and most enforcement tends to be with hourly folks. And this really stems from the amount of control that a worker has over their schedule and their activities and such, where they are exempt, versus the amount of control that an employer usually has when folks are non-exempt from overtime. But that being said, there are examples of exempt from overtime workers, people on salaries who have one meal and rest period cases. So the requirement is the same, but where an employee sets their own day, there tends to be less litigation and complaint about that. And the more you move towards professionals who have, absolute discretion over the way that they use their day, and very little supervision over these things, it becomes a harder thing for an employee to prove and less likely for them to complain about. But they do apply as to both.
That's great. Thank you so much. If the company policy is a duty-free paid meal break of 45 minutes, does the employee still need to clock out?
Yes. Well, Max, I know this is one of your slides. If you want to go ahead and cover it.
No, please. You're good.
All right. So what happens is that, first of all, if you duty-free means duty-free. It doesn't mean, hey, since you're staying here for lunch, pick up the phone, that sort of thing. Or an inference that, hey, listen, yeah, you can go ahead and take off for a meal or rest period, but we're really busy. Those things are going to probably trigger the premium. And so if somebody is refused, if the employer, your responsibility is to make it available to them. I know employees aren't horses, but you can't, they say you can lead a horse to water, you can't make them drink. As long as you rightfully make that time available for the employee, if they choose not to take it, I would probably get it in writing that they decided not to that day. But if they're on their lunch and meal period, and if you have a punch clock or punch cards or whatever for at least tracking meal periods, you should be doing that, because as Max mentioned earlier, if you don't have the records and the employee claims that they wanted or tried to take them, and you don't have records that show that they got them, it might be a tough to meet your burden in a hearing.
That's super helpful. Anything you want to add, Max? Or
no, I think that covered it.
Okay. We've got about 2 minutes left and a couple questions left, so we probably won't get to all of them. We'll do our best to summarize and send out additional notes after today's session. So time for one more. Are paid lunches allowed, or does that lunch break period have to be unpaid?
So whether you compensate a lunch period or not is not usually the concern. Paying somebody an extra half hour of wages out of the goodness of your heart and giving them a 30-minute duty-free meal period would be fine. Again, the issue though is where they're compensated and then they work. Number one, that Donahue versus ABN case, if you're not taking them off the clock, you would still want to record that they took the meal period, even though you're paying them through it. And further, you would want to be careful that they didn't just continue to work, because if they continued to work, that would be an on-duty meal period, which in certain types of employment, a written waiver can allow for this. But that's a very specific thing with a written waiver to be done ahead of time. So usually the way people do it is that they have folks clock out. That creates the lunch period on the time records. And you can just compensate them more per hour on their salary in another way. But I don't see anything particularly illegal about compensating somebody more than whatever's promised in many contexts at all.
That's great. So we are right at time, and I want to be respectful of everybody's time, but I did want to thank our speakers and presenters for today. You guys just shared so much helpful information. Appreciate the partnership. And we'll be sending out an email tomorrow with the link to the presentation and helpful links. And thank you so much for joining today, and hope you enjoyed this session. I hope it was informative to you, and look forward to future sessions. Thank you, and have a great rest of your week, everybody, and a great weekend.
Thank you.
Thank you.
Thank you.